Welcome, everyone. Thank you for joining us today. We are excited to present this second part of our three-part webinar series, Mastering GLP-1 Compounding, Regulatory Insights, Business Strategies, Reimbursement, Telehealth, and Legal Considerations. My name is Jesse Dresser. I'm a partner with Frier, Levitt, a boutique healthcare life science law firm. I chair the firm's pharmacy practice group. I represent a wide range of pharmacy providers, including issues related to payer, issues, PBMs, PBM audit appeals, network terminations, network access, credentialing applications, and reimbursement matters. I also represent other healthcare and life science entities, including healthcare providers, pharmaceutical manufacturers, repackagers, wholesale distributors, and other healthcare technology companies. I'm pleased to be joined by my colleague, Arielle Miliambro. Together, we're going to talk about the latest strategies and legal considerations for compounding pharmacies, including innovative business models and direct-to-consumer advertising in the GLP-1 space, prescriber and pharmacy relationships, as well as the Anti-Kickback Statute, the intricacies of direct-to-consumer models via telehealth, and payment challenges for compounded and other GLP-1 medications. Arielle, would you mind introducing yourself?
I'm Arielle Miliambro. I'm a partner in our regulatory group, and I focus on matters related to telehealth and digital technology, fraud, waste, and abuse, privacy and security, and professional board rules, such as those that are relating to fee splitting, scope of practice, and prescribing and dispensing requirements. My team and I frequently work on matters that involve marketing and MSOs, physician dispensing models, and arrangements that are implicating other various licensing board rules.
Great. So before we begin, a couple housekeeping items. So this webinar will be recorded and you will receive a link to view the webinar on demand after the presentation. During the presentation, you can send us questions using the Q&A tab on your screen. These questions are private and are visible only to the presenters. We'll answer as many questions as we can at the end of our presentation, time permitting. But if you'd like to follow up with your questions at a later date, you can use the emails and phone numbers that are included on our screen. So I'm Jesse J. Dresser at frierlevitt.com, and Arielle is A. Miliambro at frierlevitt.com. So feel free to contact us anytime. The other thing I'll mention, part 3 of this series is scheduled for June 26th, where Martha Ramore and Matthew Modafferi will cover navigating litigation and intellectual property in 503A compounding. So with that, let's get started. I'll kick it over to Arielle to get us going.
So the first concept that's important to level set is the different novel or creative business models that can arise in this space with respect to GLP-1s or frankly any prescription drug, and how many variations exist of these models. And as we dive deeper into the different issues that can be presented by the different models, we're going to focus on the care being delivered via telehealth. But the telehealth aspect of the businesses is just one complexity. So even where care were to be delivered in person in some of these models, the workflow variation that I'm going to run through is going to essentially stay the same. One thing I also want to mention before we dive in is that the dynamics here are very highly nuanced. And so the compliance of the models and the different regulatory issues that present themselves, which I'll get into momentarily, are going to be fact specific. So the workflows that are described aren't in and of themselves compliant or non-compliant necessarily. So this first model that is on the screen right now, we can frame as the standard insurance model, where we have a prescriber who's evaluating a patient, they're billing an insurer for their service, they're issuing a prescription, sending that script to a pharmacy that's either local to the patient or in network for the patient, pharmacies dispensing and mailing to the patient, or the patient's picking it up, and the pharmacy's billing a PBM for the product. This model is a little bit less common with the GLP-1 focused models because, first of all, the shortage of brand products, but also because of the coverage that's available for the products or lack thereof based on the relevant prescribing indications and the fact that it's a compound versus the finished brand drug. And Jesse will get into the reimbursement issues later on, but that's just one reason why other cash-based or partial cash models have started to develop. Next slide, Jesse. So moving into the partial insurance models, we basically have the same workflow as the standard model, except that one of the providers is charging cash. So in the first workflow we have here, we still have the provider evaluating the patient, billing, prescribing, pharmacies receiving the script and dispensing, but they're charging the patient on a cash basis. And there's several variations of just this model, but the most common situation we see where this applies or is appropriate is where an existing practice is treating an existing patient and the patient's obtaining a prescription for a product for which there's no insurance coverage. So the provider or the patient is identifying a cash pharmacy that's available to fill the script. The other model that we have below here is one where the provider is charging cash, but the pharmacy is billing the PBM. And so this is most common in a telehealth situation where providers, these are new patients to providers that are coming in. The providers may not be in network with a particular patient's payer, or they may not want to concern themselves with the threshold requirements for billing to a particular payer. Because there's a difference between a legal or permissible telehealth encounter and a reimbursable one. So the provider charges cash and sends the patient through the rest of the workflow in a similar manner to the standard insurance model. And again, for the reason I described above, or on the model above, this may not be the most typical workflow for the GLP-1 focused businesses due to the lack of payer coverage for the drug. Next slide, please. So then we get into the all cash models. Because of the limitations that are associated with reimbursement, we are seeing these become the prominent variation of the model structures or the workflows. And they can work in a number of ways. So in one model that we have here, we might refer to that as a network fulfillment model that's not entirely integrated, where the practitioner charges cash and so does the pharmacy. So typically the provider has an arrangement with the pharmacy where for any referrals that the provider sends to that pharmacy, the pharmacy agrees to charge the patient a certain network rate or preferred rate because they came from that particular provider. The provider and the pharmacy generally don't have any other contractual relationship and certainly no tangential relationship outside of this agreed upon rate schedule. And each entity has direct interaction and a separate financial transaction with the patient. Alternatively, we're seeing these single pay models where the prescriber and the pharmacy are more integrated. Specifically, the provider is collecting a single fee from the patient. Sometimes it may be characterized as a subscription fee or a membership fee. And that fee is inclusive of the provider's professional services, any administrative or technology services that may be relevant, as well as the fee that's due to the pharmacy. And after the prescription is sent to the pharmacy is dispensing, sending an invoice to the prescriber, noting each prescription that was dispensed at that network or preferred rate, and the prescriber remits payment to the pharmacy. So one of the most significant aspects of compliance in this particular type of a relationship is going to hinge on whether the prescriber is viewed as paying the pharmacy for the drug versus remitting payment to the pharmacy on behalf of the patient, coming from the patient's monthly fee. And we'll get into the weeds on that a bit in a few minutes. Next slide. So we're also seeing providers evaluating vertical integration of the pharmacy component of this model. We've seen physician practices aim to either acquire or develop their own wholly owned pharmacy. Fundamentally, the model functions the same way, except the pharmacy and the physician practice have common ownership. So the prescriber is directly financially benefiting from the referral. Physician ownership of a pharmacy can bring additional regulatory complexities into the fold. So if a physician's only a part owner of a pharmacy, for example, let's say they're approached by a compounding pharmacy who offers them an interest in the business as incentive for participating in the GLP-1 focus model so that the physician has more skin in the game, so to speak, that may have ramifications from a self-referral perspective. Specifically, physicians are prohibited from making referrals of certain health services to entities that they have financial relationships with at both a federal and state level. And so that has to be evaluated in those circumstances to make sure that the model is structured properly. And we'll get into that a little bit more in a moment as well. Next slide, please. So, and then another variation of this concept of vertical integration sort of would be for the physician to directly dispense or administer the prescription product to the patient rather than using the services of a pharmacy. And up until now, we're primarily talking about models that use 503A compounding, whether by an independent pharmacy or in the last model, a physician-owned 503A pharmacy. But where you have physician dispensing directly or administering, they theoretically would be acquiring the compound from a 503B facility. And so there's various differences between 503A and 503B compounding models, which Jesse will get into now.
So one things I wanted to bring up before we kind of transition over there, and Arielle, maybe you can comment on this, is where practices such as white bagging fit in these different types of models. Because obviously here we're talking about office use where you have a product that is being made non-patient specific and used and held by the prescriber and the administrating physician for later use. But conceivably, there could also be a framework where the administration is still done in office, but the products are being made pursuant to a patient prescription. So I'm wondering if maybe you can comment on that for a moment before we hop over.
Sure. And the workflows, if you go back a few slides really to any of the pharmacy slides other than the physician-owned pharmacy, it's going to function the same. The pharmacy still dispensing. It's just a question of whether or not the pharmacy is shipping to the patient or shipping to the practitioner as an agent of the patient. And if they're shipping to the patient, bringing the product to the physician's office for administration versus it already being there when they arrive for the appointment for administration. And so there's definitely board rules that relate to whether or not a physician can do that in some states, or whether a pharmacy rather can send it to a physician on behalf of the patient. And in others, it's silent, and the physician can act as an agent in that way. But this workflow doesn't really change when we're talking about administering the product. The pharmacy is still the one that's dispensing it.
And the other thing I'll mention, we're talking mainly about prescriptions, including semaglutide and GLP-1s. The one comment I'll also make too is if a prescription involves a controlled substance, there's going to be different rules that are going to be applicable based on DEA rules, not necessarily FDA or boards of pharmacy, but issues with the DEA of dispensing to basically an agent to the patient as opposed to the patient themselves. So just important to keep in mind. So with that, let's talk a little bit about the differences between 503A versus 503B compounding. So 503A compounding, this is where you are compounding pursuant to a state pharmacy license. You are being regulated by the boards of pharmacy. It has been around for quite some time. There had been a statutory exemption from the new drug requirements for pharmacy patient-specific compounding that had been challenged and repealed for a long time. And then in 2013, it was reinstituted explicitly. So now there's an explicit exemption to the new drug requirements to allow for patient-specific compounding by a state licensed pharmacy. At the same time, in 2013, Congress also created 503B outsourcing facilities. These are entities that may or may not be a pharmacy, don't have to be a pharmacy, although they could be, that are designed to provide greater levels of CGMP compliance. They are endowed with abilities to compound sterile products and validate those sterile products, and importantly, do so in the absence of a patient-specific prescription. There are, however, different rules that apply to these different facilities. So it's important to kind of take note of what those rules are, as well as what the additional rights and opportunities are. So under 503A, they can only compound pursuant to a patient-specific prescription. It has to be an individually identified patient, and it has to be pursuant to that prescription. They can't compound for office use. At the same time, 503B outsourcing facilities, they can compound pursuant to a patient-specific prescription, although if they do so, they typically have to be licensed as a pharmacy as well. But importantly, they can engage in office use compounding. So that means that they can provide stock to a healthcare facility or a physician who can then use as patients come in. Whereas what we were just talking about a minute ago, a 503A pharmacy can only do so in the confines of white bagging, where that product is actually labeled for a particular patient and held in the doctor's office for a particular patient and cannot be used for anyone else. In terms of anticipatory compounding, 503As are limited. They can only do in limited quantities based on a history of prescriptions. Compare that with 503Bs that can engage in broad-scale anticipatory compounding in advance of orders. There are, importantly, some simmering interstate distribution potential limitations that may apply in the 503A space that won't apply in the 503B space. Under the law, there's a requirement the FDA put out a rule on interstate distribution of compounds in excess of 5% of a pharmacy's orders. The FDA has spent the past 11 years trying to come up with how they're going to enforce that and codify that, and it's gone through multiple rounds of drafts. It's gone through litigation. It's gone through the FDA just not wanting to have to deal with this because it's a problem. But nevertheless, on the books, there's a law that requires that limits any compounder to no more than 5% of their volume out of state, unless the state has entered into a memorandum of understanding with the FDA regarding distribution of compounds in excessive quantities. You then also have issues with resale. So a 503A pharmacy, they cannot sell to someone who then in turn sells to someone else. There's certain rules around the concept of central fill, that is two licensed pharmacies sharing the same database, filling for a particular, both caring for the same patient. One pharmacy is doing the filling, the other pharmacy is basically doing the dispensing and collection. That's different than resale. But for a compound, a pharmacy cannot sell to someone who then goes and sells to someone else. There's a limitation on that resale. With the 503Bs, there is a prohibition on wholesale. 503B cannot sell through wholesale for subsequent resale, but a 503B can. There's a carve out to that wholesale prohibition to sell to other healthcare providers like hospitals, physicians' offices, for subsequent administration to patients. And conceivably, those providers may charge that patient for that administration, both for the professional services and the drug. Now, interestingly, about a year ago, the FDA came out with draft guidance, again, it's draft at this point, that permitted the sale of compounded products from a 503B facility to a licensed pharmacy for subsequent dispensing to a patient. So compare that to office use, where you are giving it to a healthcare facility. They are not allowing it to leave the premises. They are not giving it to the patient. They are using it in a procedure. They're administering it to the patient. Compare that with pharmacy dispensing, where essentially a licensed pharmacy is giving the drug to the patient, who then can go and self-administer and take on their way. The FDA has said that act of the 503B supplying the 503A is not resale. It's not prohibited wholesaling, but it's raised a lot of questions on how that works. Typically, pharmacies can only source from either the manufacturer or from licensed wholesale distributors. And so there's a question of what happens when you source a drug from a 503B facility that then you're going and dispensing to the patient. But nevertheless, it has created a lot of opportunities and a lot of innovative models that we've seen over the past year or so of pharmacies trying to leverage 503B sterile compounding to get greater coverage for some of these compounded products. Another important concept too that's important to as we talk about the GLP-1 space in particular is the difference in which bulk ingredients can be used in compounding. So under the Food, Drug, and Cosmetic Act, Drug Quality and Security Act, applicable to 503A licensed pharmacies, a compounding pharmacy can use any bulk active pharmaceutical ingredient that has a USP or National Formulary monograph, or is a component of an FDA-approved drug, or appears on a list developed by the FDA of drugs that neither have a monograph nor are components of an FDA-approved drug, but that the FDA has nevertheless deemed to be okay to use in compound. Now, in addition, they also have to be accompanied by a certificate of analysis. They have to be made by an FDA-approved facility. They have to not be on a recall list. There's a couple other criteria that go into it, but for the most part, any bulk ingredient that either has a monograph, is part of an FDA-approved drug, or the FDA is otherwise deemed is okay to use in compounding can be used. It's a permissive standard. Compare that with the standard to use bulk ingredients in 503B outsourcing facilities. They cannot use a bulk ingredient unless the products themselves are on the FDA shortage list, or the bulk ingredient is on a formally approved list developed by the FDA of products that they've deemed to be capable of being used by outsourcing facilities. So unless your product is on that list, you cannot use a bulk API in compounding through an outsourcing facility unless the drug is otherwise in short supply. So that's where we're at now. We are in the concept of dealing with semaglutide and other GLP-1s that are in short supply, that are deemed by the FDA to be in short supply. And as a result, it has created a big opportunity for not only compounding pharmacies, but especially outsourcing facilities to engage in compounding of these products and using bulk active pharmaceutical ingredients, as opposed to only being able to use FDA-approved ingredients or ingredients that otherwise the FDA has included on the list. So what does that mean? So right now, while semaglutides are on the drug shortage list, 503As can compound semaglutides using the bulk APIs, and 503Bs can compound it, but only while it's on that shortage list. But the moment those semaglutide products come off the shortage list, the 503A could still compound it using bulk active pharmaceutical ingredients, but only so long as it's not essentially a copy of a commercially available product. Right now, there's a pass that traditional licensed pharmacies have when it comes to compounding using bulk APIs and even products that are copies, because the product is in short supply. But once it comes off short supply, there's going to have to be a meaningful clinical difference between the product that's being compounded and the FDA-approved ingredient if it's no longer in short supply. But compare that to 503Bs. The moment that these products come off the shortage list, the 503B facilities will not be able to compound it using the bulk APIs, even if there is a meaningful clinical difference between the product being made and the FDA-approved ingredient. So important to keep in mind as we talk through opportunities right now, but also as we talk through long-term strategies and thinking. And as a result of this, we have had a lot of clients come to us and say, I want to start both a 503A and a 503B facility because I want to be able to capture both opportunities. I want to be able to do some of the office use compounding. I want to be able to do broader batches. I want to be able to potentially even sell to other 503A pharmacies. But at the same time, I recognize that if I'm going to invest resources into acquiring clean room supplies and equipment, if I'm going to invest the time to certify my equipment and validate my products, I don't want it to be limited to whatever I could do while the products are on the short supply list. I want to be able to have this be a long-term venture. And so that's why we've seen a lot of folks come to us with that idea of maybe doing both. And there are some rules around being both. There is some rules around having two essentially facilities in two licenses or registrations in one facility. Some important kind of business decisions that have to be made, some compliance considerations that need to be taken into account, but definitely something that we've worked with folks and evaluated. So with that background, why don't we switch gears and talk about some of the payment considerations that we've seen and how that's impacted these different models.
So in terms of some of the regulatory issues that arise in the single payment models, We can first start with discussing the federal anti-kickback statute, which prohibits providing anything of value to someone in exchange for a referral. And while the federal anti-kickback statute only applies to directly only applies to arrangements where there's a federal claim at issue or federal healthcare program, most states have similar prohibitions, and in many cases, those state rules will apply irrespective of the payer. So they can even apply in a cash-based model. Frequently, those state rules are going to cite back to the federal AKS in terms of safe harbors and exceptions for different types of relationships that are permitted. So in many states, even if the parties to a particular arrangement are building a cash-based business model, their compliance with the federal safe harbors will put them in a position to potentially survive scrutiny under state law. In most of the product-focused models that are going to involve a prescriber and a pharmacy component, kickback rules are going to be triggered in some capacity. Just as a few examples, in that integrated single payment subscription type model I described a moment ago, if the prescriber obtains payment from the patient and passes through a portion of that to the pharmacy for the cost of the drug that's being dispensed, that payment can trigger a kickback prohibition if it's not consistent with fair market value. So if the payment to the pharmacy is representing a significant discount from what the pharmacy would ordinarily charge a patient, that discount could be viewed as a kickback from the pharmacy to the prescriber for sending the referral, because it allows the prescriber to keep a greater portion of that subscription fee that they collected from the patient. Whereas in a model where the prescriber and the pharmacy are each charging the patient directly and they don't have a financial tie to each other, that's not going to be as much of an issue. In a vertical type model, whether through a vertical pharmacy or even a physician dispensing and administration model, where the physician's referring back to themselves, kickback rules can also be implicated based on the financial benefit that the physician receives from their ownership in the practice or in the practice's pharmacy as a result of that referral. So each model can trigger these rules in different ways, and stakeholders just need to be aware of it and how they're implicating kickback prohibitions so they can develop or modify their relationships to comply with a relevant safe harbor, again, whether at the federal or state level. From a state perspective, parties need to really ask the question of whether there are state kickback rules that are going to apply, because in some states, there's not going to be an any payer prohibition. And if you're dealing in only cash and you're not sending, a commercial claim or a Medicaid claim, then there may not be a kickback prohibition that's going to attach. One thing to mention is that many of the boards have their own sort of semi-kickback prohibitions, often in like unprofessional conduct sections. And so that has to be kept in mind as well. But knowing whether or not those rules exist and if they are getting triggered by the model, and then what needs to be done to ensure that the model stays above board, and what safe harbors or exceptions are going to be relevant. Fee splitting rules, back on the last slide, just one more point. Fee splitting rules are state specific, and they typically prohibit a licensee from sharing or dividing their professional fees with a non-licensee or someone who didn't contribute to rendering professional services. It's fee splitting similar to kickbacks, but it doesn't require the quid pro quo. So there doesn't have to be a referral in exchange for payment. It's just payment being made to someone who wasn't involved in the professional service. So this is another regulatory consideration stakeholders, particularly the licensed stakeholders in the model, need to be aware of, because most of these rules too are in the context of licensing boards and unprofessional conduct, and states really vary widely on how they address fee splitting. So New Jersey, for example, doesn't have a broad fee splitting prohibition separate from the potential implications of corporate practice of medicine, which I'll jump into in a bit, but New York does. So it's important to know where you stand in the states where you're operating. Now we can go to the next slide. At a basic level, Stark is a federal law that prohibits a physician from making a referral of a designated health service, which includes outpatient drugs, to an entity that the physician has a financial relationship with. And these financial relationships can exist by virtue of ownership, but also by virtue of a compensation arrangement. Importantly, Stark only applies to Medicare and Medicaid referrals. So for that reason, in most circumstances, Stark's not going to apply to the models we're discussing here because the drugs aren't being submitted for reimbursement. But there are state-specific self-referral rules that may apply irrespective of payment. And those state-specific rules may be more broad than Stark because, like the state-specific kickback rules, they may apply irrespective of who's paying. So these self-referral rules could be triggered even when it's a cash-based model. But while they're broad in that sense, they may be more limited in others. So, for example, some states have very limited definitions of what a designated health service is, which is the type of service that wouldn't be able to be referred. And in some jurisdictions, an outpatient drug isn't a designated health service, so it's not going to trigger those self-referral rules. Again, it's really just important to understand the laws in the state where the parties are operating and then structure the financial relationships carefully to make sure that if there is a relationship between the prescriber and the pharmacy, the flow doesn't violate those prohibitions. Separately, some states have laws that directly apply to a physician's sale of a product to a patient. So again, New Jersey as an example, the BME, the Board of Medical Examiners, prohibits practitioners from charging in excess of their cost plus 10% when they're dispensing drugs to a patient. So a rule like this could be implicated in a physician dispensing or administration model and impacts how the physician is going to charge. But it could also be implicated where the physician owns a pharmacy and possibly even in the single subscription fee model if that's not structured properly. And on that latter point, with the subscription model, if the physician's viewed as selling the pharmacy dispensed prescription in that subscription model, it could be considered unlicensed practice of pharmacy. So it really highlights the importance of proper communication and representations to the patients, but also in the contracts. We've seen a lot of contracts that are indicative of a relationship where the pharmacy is really just selling the product to the practice. And in a 503A model, as Jesse was describing, that type of language should really be avoided because the pharmacy is the one dispensing, and the product can't be resold or redispensed by the provider. So it has to be clear that the practice is merely transmitting the patient's payment to the pharmacy on behalf of the patient. They're not selling the product to the patient. Next slide. So moving on to the delivery aspect of telehealth in these models, when we're talking about telehealth, we're talking about the provision of a healthcare service from a provider in a location who's not in the same place as the patient that they're treating. Telehealth can be conducted through different modalities depending on the state. So some states allow for asynchronous store and forward encounters, and other circumstances or other states may require a live two-way audio video conference in order to interact with the patient. We're seeing some states also impose rules that require the provider to obtain patient history from either a health information exchange or from another practitioner who's treated the patient rather than from the patient directly, especially in a circumstance where the rest of the communication is asynchronous. So that's something to keep in mind as well. And many states also have limitations on prescribing via telehealth if the ordering is based exclusively on an online questionnaire without any other interaction or information or diagnostic imaging from the patient. So the modality that the telehealth is delivered through is going to depend on the particular state law where the patient is located, but it's also going to depend on what the standard of care is for the service that's being delivered, as well as any applicable payer requirement if reimbursement's being sought by the prescriber, which we are seeing in a handful of the GLP-1 models out there, where even though the pharmacy, like the breakdown that I had presented earlier on the screen, even though the pharmacy is not billing, the provider still is. In terms of licensing, generally telehealth is going to occur at the site where the patient's located. So the practitioner needs to be permitted to render treatment in that jurisdiction. Most of the time, that's going to require licensure like a full license in accordance with the state's conventional licensing process. Some states do have a process or procedure for getting a limited telehealth license. A very small number of states have a registration requirement that's not really licensure in that state. It's more of a notification to the board that you're licensed in another state and you intend to be providing care virtually into that state. So Florida is an example of that. There's also some states with exceptions to licensure, but typically that's for discrete or infrequent care being delivered or clinician to clinician consultations. So that's not typically going to be relevant in most of the models that we're discussing today. So what we're really talking about is the physician or practitioner is going to need some type of license or notification in the relevant state where they're treating patients. Creating a bona fide relationship with the patient and engaging in a bona fide telehealth encounter, that's something that's not only necessary for purposes of compliance with licensing board regs, but it also has a direct impact on whether the prescription that results from the encounter is going to be viewed as valid. So different states, again, nuanced requirements for establishing that bona fide relationship via telehealth. And that those requirements may be based on the modality that's being used, could be whether certain disclosures are made to the patient, whether the provider is properly documenting the encounter, whether they've got consent from the patient to provide telehealth. And again, whether the standard of care was reasonably met through that virtual interaction. And so where an encounter is not bona fide, or where the encounter doesn't create a bona fide practitioner-patient relationship from a licensing board perspective, the provider could be subject to discipline, but it also affects the pharmacy, and the pharmacy could face scrutiny for dispensing an invalid prescription. And that raises questions regarding what the pharmacist's obligations are with respect to validating a prescription before they dispense. And so again, different boards are going to impose different obligations, different duties on the pharmacist with respect to that process. Next slide. So separate from the licensing components, there can be also concerns related to practice structure and corporate practice of medicine. So the corporate practice of medicine doctrine, generally it prohibits a business corporation from practicing medicine or engaging a practitioner to provide professional services on its behalf. And the prohibition is intended to prevent unlicensed individuals from exerting control over medical practices or licensees to preserve the integrity of a licensee's professional judgment. So corporate practice of medicine, or CPOM, the applicability across states can really be viewed on a spectrum. There's states that don't have any corporate practice prohibition. Those are going to be the most flexible. In a state like that, a non-licensee, Jesse or I, could own a medical practice and hire a physician out of that medical practice to provide care. Then there's going to be states that require majority ownership by a physician who's licensed, whether it's in that state or another state, as long as they're licensed, but a non-licensee can be a minority owner. Then there's going to be states that require exclusive ownership by physicians, but they can be licensed in another state. They don't have to be licensed in that state, but a non-licensee couldn't be an owner. And then sort of the highest level is a state that's only going to allow licensees in that state to own a practice. So again, New Jersey example, that's one of the strictest corporate practice of medicine states. And to practice in a permissible capacity, providers can be part of an entity that's owned solely by the same type of licensee or closely allied provider. So in a state like New Jersey, a non-clinician cannot be an owner of a medical practice. They cannot hire a physician to render care. And that's a really critical point, because we see a lot of models that are driven by unlicensed individuals who appear to be paying physicians for providing their professional services. And these models present risk for that reason. So providers, especially providers, should be aware of corporate practice rules in their state, because they're the ones that are subject to the license discipline or other adverse action for participating in a model that is in violation of that state's corporate practice rules.
One thing I want to mention before you get into the anti-kickback statute piece, Arielle, is kind of the opposite of this, which is some of the unique rules we've seen at the Board of Pharmacy level around physicians owning pharmacies. So there are a slew of states that limit either altogether any physician practice from becoming licensed as a pharmacy. Sometimes they require the physicians to do it through in-office dispensing. But there are a couple states where if any of the owners are physicians, they won't issue a pharmacy permit. We've seen that in California. We've seen that in Indiana. There are a couple states where you almost have to have the same kind of analysis being done from the opposite perspective if you are looking to have physicians get involved in the either ownership or in the dispensing process itself.
Definitely. And before we transition off of corporate practice, from a telehealth perspective, corporate practice gets even more complicated because the physician has to be licensed in the state where they want to render care, but they also have to be practicing through a permissible entity structure in each of those applicable states. So there's so many different permutations of those situations where, let's say, one provider in a practice is licensed in another state and they want to render care via telehealth into that state, but the rest of the shareholders aren't. And then how that overlays with that new state's corporate practice rules and whether or not those non-licensees, even though they're, let's say, licensed in Jersey, but they're not licensed in the new state, how that overlays with that state's corporate practice rules. In addition to making sure the entity is properly structured, there's also the question of whether or not it has to foreign qualify in another state in order to render care there. So foreign qualification is essentially the process of notifying the Secretary of State in another jurisdiction that you're going to be doing business in that state, which would be the case if providers are rendering telehealth through an entity that's formed and operating in a different state. But depending on corporate practice rules, certain states don't allow for foreign qualification of medical practices. So it's a web that kind of has to be really carefully configured to get multi-state coverage. And so because of that, a lot of the models that outwardly appear to be these national models are actually multiple practices operating as a network or pseudo network. And frequently they're branded by a single management service organization or MSO that acts as that centralized hub for the administrative components relevant to the model. And so that's why it appears as just one. They're all branded by the same MSO. As we touched on above with kickbacks and fee splitting prohibitions, it can also come into play with the telehealth model separate from the physician pharmacy dynamic. It's a decreasingly common and impermissible arrangement in telehealth is one where the provider is compensated by a telehealth company for his or her professional medical services. And the issue is that telehealth company is frequently getting the money to pay the provider from either a marketing group on behalf of an ancillary provider or from an ancillary provider directly, like a pharmacy, a lab, a DME. And so the provider may not even be aware of where the money's coming from. But then at the conclusion of the encounter that they've been paid for, if a prescription gets issued, it's submitted back to that ancillary provider whose payment was originally used to compensate the physician. So you have the ancillary provider indirectly paying the physician, and in exchange, they get a referral. This is a kickback model that's been prosecuted very regularly over the past several years. And, we've also seen other ramifications of that with provider ordering privileges being revoked. Both with respect to the actual telehealth model, but also their other business arrangements. A lot of the providers that are practicing via telehealth, that's not their full-time position, and so that needs to be contemplated when a practitioner's considering getting involved in a telehealth model, is how it's going to impact the other mechanisms that or practices that they're rendering care through, and the contracts that they have with payers in that capacity. So again, ultimately, just all stakeholders have to be aware of the totality of the telehealth model that they're participating in to properly evaluate their exposure.
So with that, we'll talk a little bit about some marketing considerations. And the first one dovetails with the item that you were just mentioning, Arielle, about the impact of anti-kickback statute and the relationship between it among the stakeholders. One of the concepts that we've seen many different stakeholders, whether they be physicians, whether they be pharmacies or outsourcing facilities, that they are approached by is marketers who are either looking to drive volume or even marketers that are looking to bring them into a network of physicians or a network of pharmacies that the stakeholder can just plug into. So Arielle, you want to comment a little bit on some of the kickback considerations and risks associated with those types of models?
Yeah, sure. We've seen a lot of telehealth models surrounding many drug products, not just GLP-1s, but that purport to have the prescribers and the pharmacy ready to go. And the marketing arm can kind of come in, drive patients to a particular web address, and then hand those patients off to this plug and play type model, where the patient then can get a prescription from a clinician, and then the patient would receive the drug by mail from one of these pharmacies that's affiliated with this network. Most of the time, these plug-in models present themselves in a way that appears to just allow the marketing arm to keep a cut of the business that gets generated by the rest of the parties in the model, specifically the physician's fees, or more importantly, the pharmacy's fees and the drug revenue. And this is a dynamic that has to really be carefully scrutinized. And anyone that's anywhere in either of those, 3 or 4 parties needs to conduct diligence as to what the others are doing, so that nobody's exposing themselves to liability for, the partners in this type of business structure and their activities, especially from a kickback perspective. So again, it comes down to structuring the financials properly, and making sure that they're transmitted among the parties carefully to avoid unnecessary risk.
Great. So a couple other things to keep in mind when it comes to promoting these types of models and marketing them. There are a variety of rules that apply to marketing and advertising of any kind. For example, the Federal Trade Commission has rules around the ability to create advertising or marketing. The advertising cannot be false or misleading, so you have to make sure that anything that you're saying can be backed up with evidence and can be supported, and that it isn't viewed as being false or misleading to a consumer in accordance with FTC rules. Equally important, under the Food and Drug Administration has a series of rules that apply to pharmacy compounders, both traditional 503A licensed facility pharmacies as well as 503B outsourcing facilities. And if you are making a drug compound that is not an FDA approved product, you can't make claims of safety or efficacy, because that's the whole concept of a label that's been subject to the new drug application approval process. And if you haven't gone through that process, you don't have an approved label that you can go and make claims of safety or efficacy. So it's important on all of your marketing material, on your website, on your communications with doctors, on your pre-printed prescription pads, on your testimonials, on all of it, that you're very, very cautious, and having all of that evaluated, not just from FTC compliance perspective, but importantly from an FDA compliance perspective, to make sure that you are not promoting it as safe or efficacious in any way, because it's not been proven to be so. By definition, it's a compound and can't have those claims be made about it. Equally important too, be cautious. I always advise clients, be very, very cautious about how you name your product. Even just naming it can be viewed as a claim of safety or efficacy, or can be viewed as creation of a new drug or labeling for a new drug. So take a lot of caution in how you denote the products that you're out there promoting. The flip side of all this is more from a litigation risk, and this is going to be something that my colleagues Martha Ramori and Matt Montefiore are going to talk about during our next webinar, which is trademark considerations and the risks that you face if you start comparing your products to the branded alternatives. The makers of GLP-1s and other semaglutide products have been litigious. They have sued pharmacies and medical spas and doctors' offices and physicians and others in this space when comparisons are drawn between the FDA-approved commercially available product and these compounded products. They have claimed trademark infringement. They have made other forms of unique and kind of novel legal arguments to go after these entities. A lot of it is to try to clamp down on competition, but some of it is grounded in law. So it's important too that you're very, very cautious when you're entering into these business models, that not only what you say is not problematic and doesn't draw comparisons and doesn't make reference to the branded products, but that the other stakeholders in your integration, whether they be physicians, the telemedicine company, the marketing company, anyone else, is abiding by those same rules. Because we've had situations where we've represented a pharmacy and they're getting subpoenas from Eli Lilly, or they're getting subpoenas from Novo Nordisk, because one of the physicians that was ordering their stuff for white bagging or for in-office use was making claims, and so now they're being sucked into this and getting subpoenas. So it's important to kind of vet out the other partners that you're working with in these different types of models. So a couple other things that I'll mention from a reimbursement perspective. Most of what we're talking about here is cash. We're talking about a global fee or some kind of cash payment that's being made to the pharmacy or to the physician or to both, and it's typically not going through insurance. One of the things to keep in mind, that if this is a cash model, you have to be cautious about separating your cash versus non-cash business. So if you are a pharmacy and you do participate in PBM networks for other non-compounded GLP-1 products, you carving that out could create contractual issues with your participation. There are certain requirements to be able to not charge otherwise insured patients cash for products that would otherwise be covered by insurance. That's a typical provision in many PBM contracts. At the same time, too, the same goes for usual and customary. If you are offering a product for a cash price that is much lower than what you would charge the PBM for that same product, you could run into a usual and customary concern where the PBM is going to say, we want the lower price that you were willing to sell to a cash paying patient. Same goes too for physicians. If you are a physician and you are basically providing weight loss consultation for cash and charging a rate, there becomes issues with your participation with not only commercial major medical plans, but also Medicare. And there's a whole process to go about being designated as non-par, non-participation under Medicare. And you could run into issues by providing self-pay or patient pay care for something that could otherwise be covered by Medicare or one of the other programs. I know a lot of folks also have been involved in billing of traditional FDA-approved GLP-1s and semaglutide products when they can get their hands on them, when they have patients. We have seen some reimbursement risks associated with that. I'll mention some of those quickly. Related to audits, there's a growing sense among PBMs to scrutinize these claims, to look for little gotcha things like that you didn't note BMI when you should have, that you didn't validate that the patient had diabetes when you should have. Different little things to be considered, to be mindful of if you are doing some of the commercially available products and are billing insurance. The other thing that we've seen too is for some of the folks that are doing that, we've seen a big trend of below water reimbursement for a lot of these products. And so we've had folks that have turned away some of the commercially available stuff because they're losing, $150, $200 a product. And some of the PBMs have threatened and actually terminated pharmacies from the network for, allegedly turning away patients from the ability to get their coverage because the pharmacy didn't want to lose money on the prescriptions. In addition to being aware of that as a concept, you should also be aware of that if you are engaged in PBM billing and you are facing below water reimbursement rates, there usually are some legal strategies that may apply. So just something to consider if you're in that space, but just another risk too, that if you're turning away patients because of underwater reimbursement rates, there is a potential for termination risk as it relates to your other PBM business. So in a couple of minutes that remain, I'll also mention a couple other miscellaneous things that we've seen. One of the things that we've seen a growing push for is employers looking to carve out GLP-1s and semaglutide products from coverage altogether, and instead require that patients either go through alternative models to get it, maybe get compounded models, or maybe even get it through the 340B program. 340B program is a federally mandated program that requires manufacturers to sell drugs to covered entities at below market prices. And so we've seen some models where pharmacies have partnered with covered entities to try to get GLP-1 commercially available GLP-1 products at 340B prices and pass the savings on to the members. Another concept I'll mention quickly, we've seen a growing number of the actual GLP-1 manufacturers launch their own version of telemedicine and direct-to-consumer models. It offers a potential opportunity for pharmacies to become fulfillment partners with some of those manufacturers. And so that's another thing to kind of consider as another avenue or innovative business model in this space. So we have about 5 minutes left, and there have been a couple of questions that have come in. If you have any other questions, feel free to shoot them now, and if we can't get to them during the webinar, we can follow up with you. But Arielle, do you want to maybe touch on some of the questions?
Sure. So one of the questions was if there is a pharmacy that's licensed in a particular state but doesn't have the ability to compound, and it is commonly owned with a pharmacy that's licensed and located in a different state. And that second pharmacy, Pharmacy B, doesn't have licensure in the original state but can compound. Then can Pharmacy A process the prescription since it's licensed in the state and use Pharmacy B to actually complete the compounding process? All this under the assumption that they share common ownership. So the way I'm reading this, it sounds like a shared services or central fill type of relationship. And where there are board rules on central fill, so some boards are silent, some boards explicitly permit it and delineate exactly what needs to be done, and other boards prohibit it. The common denominator that is going to be relevant is that if a pharmacy is going to be participating, even through shared services like this, in the dispensing process, then they have to be licensed in the state of the relevant prescription. So if Pharmacy B here is not licensed in Pharmacy A's state, then Pharmacy A can't delegate a prescription in that state to Pharmacy B, even for a portion of the services. Pharmacy B would have to be licensed. Another question that came in is when a telehealth entity is collecting the full amount from the patient and the telehealth entity is paying the prescriber and paying the pharmacy for each of their services, how does that fall into the models that we described? So this in terms of the workflow, we're really talking about the integrated workflow, and that's the flow of the prescription from the prescriber to the affiliated or integrated pharmacy. Everybody's charging cash. When you say telehealth entity, I'm going to equate that to an MSO because that's typically what these entities are. Those are the ones that are taking on the administrative tasks, including billing and collections. And the question of whether or not a model like this is compliant or not it's all going to depend on the nuance. So can a third party provide that collection service to a prescriber and to a pharmacy? They could if it's structured properly. If they are engaging the provider and hiring the provider to render the service, same for the pharmacy, then it's probably not going to be compliant. So it's really going to come down to the contracts in that situation and the representations to the patient as well.
Okay. All right, so we are at 3 o'clock on the dot. There were a few other questions that came through. that we didn't get to specifically on this one, but we certainly can follow up. The other thing I'll mention is we have a third part of our webinar series that will be coming on June 26th, where Martha and Matthew will dive into navigating litigation and intellectual property in 503A compounding. Some of the questions that were asked, including around patents and other intellectual property issues, will be addressed during that. So I'd encourage you to participate. Another thing I'll mention just briefly, everything that we have shared today is for educational purposes only. So even some of the questions that we've been answering shouldn't be construed as legal advice. That being said, if you are interested in learning more and potentially getting some specific legal advice and evaluating different models, please feel free to reach out to Arielle or myself. Our contact information is here, and we'd love to work with you. So thank you again for joining us this afternoon, and we hope you found the discussion insightful and valuable.